Good afternoon. I haven't done a I haven't done a proper live in a long time because I've been busy with a whole number of things. So um, here I am. I'm online and getting this live going. I want to talk about I want to talk about the Azruddin Mohamed situation and the stay of proceedings, the interim stay that was granted because there seemed to be some confusion about it. So I want to talk about it and break it down a little. I mean, the Mohammed's case is quite interesting, and so because it's interesting, it's it it's worth the time to break it down so that people have an understanding of what really is going on here. So the case is before the magistrate, Judy Latchman, or worship at the magistrate court in Georgetown, and it involved the extradition proceedings against Mr. Nazar Mohamed and Azruddin Mohamed. Nazar is the eldest of the Mohammeds, and Azruddin is his son. Azruddin is now the leader of the opposition. At the time that the proceedings were initiated, Azruddin was not a politician. Azruddin started running for office about 3 months before the election. The elections was in September, so he sort of made up that decision in late June, early July. But he's now the leader of the opposition, so there's a little pendulum shift in any event. So Azruddin has raised the issue before the magistrate about bias and try to stop the extradition proceedings before her. And she ruled against him. Well, against them, because it's not only him, it's him and his father. So the magistrate ruled against them, and then they filed an application before the Chief Justice, and the Chief Justice dismissed their application, and he did issue the reasons for his decision, and his decision was on the 4th. Let's see, let me make sure I get the date right. They don't put the date of their decisions on top of it. So anyway, his decision was 14 pages long. So I just pulled it up. His decision was delivered on February 4th, 2026. And I'll just read the background. He says, well, a request was made by the government of the United States to the government of Guyana for the applicants to be extradited to the United States of America on charges to stand trial on a federal indictment issued by the United States of America. The request was made pursuant to 1931 extradition treaty between the United States and Great Britain. The law governing the extradition process in Guyana is the Fugitive Offenders Act, enacted in 1988 as amended by the Fugitive Offenders Amendment Act of 2009. And then the first name respondent, who is the Minister of Home Affairs, she was listed as a respondent because she issued a requisite authority to proceed pursuant to Section 12 of the Fugitive Offenders Act. And then he wrote that the applicant was arrested on October 31st, 2025 and taken before the Principal Magistrate, Judy Latchman, the presiding magistrate of the Court of Committal, in accordance with Section 15 of the Fugitive Offenders Act. The applicants were released on bail pending the determination of the committal proceedings. So the Mohammeds are on bail right now, and the magistrate commenced her proceedings. So all that is in the background that the Chief Justice has. Yeah, all that is in the background that the Chief Justice has put forth for the benefit of us. And so the applicant filed a fixed date application just before Christmas. And so that was filed on December 23rd, 2025. And the hearing was conducted on January 14th. And the main relief that the Mohammeds were seeking is a declaration that the issuance of the purported authority to proceed ATF dated October 30th, 2025 under the Fugitive Offenders Act by the Minister of Home Affairs in respect to the applicants is in breach of the principles of natural justice, ultra vires, unreasonable, irrational, arbitrary, unfair, and abuse of power, whimsical, capricious, and unfair. So, see how much words they use? They could have just said it breached the principles of natural justice and finished at that, but they went on with a whole bunch of words. Unreasonable, irrational, arbitrary, unfair, and abuse of power, whimsical, capricious, and unfair. I don't know if these lawyers are getting paid by the words. I don't know if they're getting paid by the words, but my goodness, they had to put a lot of words in there. And this is what the Chief Justice of Guyana said, the acting Chief Justice. He said the grounds in support of the relief sought in the application spans a mind-boggling 108 paragraphs containing recitations of purported facts and legal authorities in support of apparent legal conclusions. And then he said, while this court has stated previous rulings and is compelled to state again that a ground in an application to the court is the legal principle or claim being advanced or relied upon to justify granting of the relief being sought. It's the reasons specified in law that forms the basis for the relief claimed. And then he says, well, the grounds therefore cannot be a full discourse of the evidence relied upon. Okay, so you give them a little school in there. And then he says, well, the basis of the allegations is that the second named respondent, which is the Attorney General, the second named applicant, which is Azruddin Mohamed, was expected to be elected the leader of the opposition in the National Assembly at the time the ATP was issued, and he has in fact been so elected since the hearing of the fixed date application on January 14, 2026. While the FNR, the minister responsible for issuing the authority to proceed, is a member of the governing administration. And so it is argued that in this regard, the FNA is a political foe of the FNR. So the FNA is a political foe of the FNR. And this political relationship gives rise to a reasonable likelihood of bias or apparent bias sufficient to vitiate the FNR decision. Right, so that's law. I know it's a bit long, but I wanted to go over the facts first before I talk about the CCJ decision. And so he goes through the standard of review. He goes through the political circumstances of the case. He goes through how an administrative official would exercise their discretion. And then on the issue of bias, he says the court finds that the allegation of bias is not made out. The mere fact that the applicant is the leader of the opposition does not establish bad faith, improper purpose, predetermination, or unlawful bias in the exercise of the statutory power to issue an authority to proceed. And this is what he said. He says it is indeed an absurd proposition that if the FNR heard her colleagues express disdain for the applicants, then she's tainted with bias. It makes reading comments on social media a professional peril. And then he says, well, the applications of bias is duplicitous in any event because the applicant's application was filed on December 23rd, 2025, and notably the allegation was not included in the judicial review proceedings initiated by the applicant on December 15, 2025. Logically, it would be expected that the first complaint the applicant would make to the court is that the act that puts everything in motion, to wit the issuance of the ATP, should be squashed. Right? And so he basically is demolishing the case that the applicant brought. And then he speaks about the right to be heard prior to the issuance of the authority to proceed. And he says, well, the applicants submit that they were not given an opportunity to be heard before the issuance of the ATP in breach of rules of natural justice. And then he says, well, the applicants have not demonstrated that the statutory scheme for extradition provides for the subject of the request to be heard prior to the issuance of an ATP. But this is what he says here, which is interesting. He says that this is the Chief Justice acting. That's interesting. He says the court finds that this submission is yet another disingenuous submission, since it is significant to note again that on October 6, 2025, the applicant's counsel, Mr. Dujon, wrote to the FNR informing the FNR that the applicants intend to participate in the lawful extradition process as set out in the Fugitive Offenders Act, and specifically states inter alia that they will surrender to the authorities whenever the ATP is executed. And then he goes on to say, well, Mr. Dujon did not request an audience prior to the issuance of the ATP, although he clearly expressed a belief that the APT will be issued. In the circumstances, the application is dismissed in its entirety. And so he says, well, the stay of the extradition committal proceedings filed on December 24, 2025 is subsequently refused. So when he did that, which is when the Chief Justice dismissed the application, it was then moved up to the Guyana Court of Appeal. And credit goes out to the Court of Appeal. The Court of Appeal heard the matter in quite an expeditious fashion. So the Mohammeds got the hearing like in breakneck speed, and the court was able to decide this issue in short order. So the court made a decision. The court heard the matter on the 10th of March 2026 and on the 17th of March 2026, and it rendered its decision on the 17th of March. And it was a panel comprised of the Chief Justice, not the Chief Justice, but the Chancellor of the Judiciary, Roxanne George, Rishi Prasad, and the new Justice of Appeal, Narswar Harnanans, who was a High Court judge before he got elevated to the Court of Appeal. So the Chief Justice wrote the decision, and she considered the matter. And she said, well, she said Nazar Mohamed and his son Azruddin Mohamed, the leader of the opposition, are the subjects of a formal extradition request submitted by the United States government in October 2025. On receipt of that request, the Minister of Home Affairs did what the Fugitive Offenders Act requires. She issued an authority to proceed, directing the magistrate court. Warrants followed. The appellants were arrested, they were granted bail, and the proceedings commenced before the principal magistrate, Judy Latchman. And then she said that they then filed proceedings in the High Court challenging the issuance of the authority to proceed, arguing that the minister was biased when she issued it, and she was tainted by political hostility towards Azruddin Mohamed as the political rival, and further infected by the alleged bias of the Attorney General, who had provided her with legal advice in relation to the issuing of the ATP under the FOA. Fugitive Offenders Act is FOA. And she said, the Court of Appeal said, well, this court identified two issues that stood at the heart of this appeal. First, whether the rule against bias applies at all to the minister's decision to issue an ATP under Section 12 of the Act, and second, whether Section 27 of the Interpretation and General Clause Act and the Carlona Principle, whether under these two different subheadings there was any legal requirement for the minister to delegate her statutory functions or for the AG to have his advisory role assumed by someone else. And then she said, on the first issue, the court affirms that the rule against bias as a component of procedural fairness and natural justice is not combined to judicial or quasi-judicial decisions. The question has always been context dependent, and that much was accepted by all parties. Right? So she's essentially saying, look, in the administrative law sphere, where a minister is exercising his or her authority, these principles of procedural fairness and natural justice applies. But somebody is telling me, turn up the volume. Let me make sure that the volume, you know what? Tell me if the volume is turned up, because yeah, tell me if the volume is turned up now. Is the volume turned up? Somebody tell me whether the volume is turned up, because someone said the volume was low. Anyway, I was saying that in terms of administrative fairness, you know, administrative functionaries also have to conduct themselves with procedural fairness, and you know, it's all contextual. It's contextual, and It all depends on the nature of the proceedings, the legitimate expectations of the parties, and all that sort of stuff in terms of administrative law. Thank you very much. Sorry, somebody should have told me a long time ago that the volume wasn't good. So she says, when a minister considers whether to issue an ATP under Section 12, she's exercised an administrative function, and a narrowly defined one at that. The Act requires her to satisfy herself that the request has been received, that the offenses described are extraditable, and that there are no obvious bars under Section 8 and 11 of the Act. So persons whose extradition is sought is not entitled to be heard at that stage. There's no adjudicative, or there's no adjudication of competing interests. There's no determination of rights. So in effect, she's saying there's a lis inter partes here. There's no lis inter partes, sorry. And then she says, she cites the case law, she cites some case law, and she says, once the statutory requirements are met, the instrument must be issued. In those circumstances, considerations external to the Act, including whatever may have been said on a political platform, has no proper role to play. For a minister to decline to issue an ATP on such grounds would itself be a dereliction of statutory duty. Right? And then she said, well, the ATP is only a preliminary step, a gateway to the magistrate's committal proceedings, not a finding of guilt or even of sufficiency of the evidence. And then she cites Jack Warner's case. So Dwayne Wildy would be happy to know. We're talking now about Jack Warner. She says a comparison is drawn by Gregory Smith, Justice of Appeal in Trinidad, in Jack Warner versus the Attorney General of Trinidad and Tobago. And there, the Justice of Appeal said the issuance of an ATP is akin to a decision by the police to institute charges based on the available evidence. So the police only requires reasonable or probable grounds to lay the charges. Once the evidence is there, the charge follows. Bias would not be applicable. And then she says, critically, there was no challenge to the merits of the ATP itself. No one suggested that the statutory criteria was not met. The challenge was entirely to the minister's standing to act, and on the facts of this case, the challenge failed. So they were saying, because there was tension on the political arena, because Anil Nandalal, who was and still continues to be the Attorney General, made critical statements on the electoral platform, and because the minister may have said something as well on the election hosting, that there was some form of bias that may have tainted the decision. The Guyana High Court rejected that, the Magistrate Court rejected that, and the Court of Appeal rejected it as well. So none of the courts in Guyana supports that. And then she goes on to look at the Pinochet case, and they rejected the Pinochet line of cases. They said this court rejects the Pinochet line of cases in its entirety. That principle rests on a direct and personal interest that is proprietary, pecuniary, or equivalently close in the outcome of the proceedings. So somebody has a fundamental interest in the proceedings. They're self-invested in the proceedings. And she said nothing close to that appears on the facts here. Political alignment is not the same as personal interest. So y'all got to know that. Political interest is not aligned with personal interests. And then she goes on to look at the Porter analysis, but this is what she says, because the so she says, statements made during the election campaign, including those attributed to the president, the vice president, and the AG, does not establish the minister had a personal interest in the outcome, nor did they show that she had foreclosed the statutory question which she was required to address. The court also observed that a person cannot insulate himself from the statutory process simply by entering partisan politics or publicly aligning himself with a political opposition. So, whoever advised Azruddin Mohamed advised him very well, because they told him, look, if you form a political party and you run, it is quite likely that you would have some form of cloak, some form of protection, in the given your high constitutional office. So somebody told him that, and so his argument now rests on the fact that I'm a political rival of the PPP, and because I'm a political rival of the PPP, all this is retaliation. Of course, the argument was made before the Court of Appeal or the lower court that the Americans are discriminating against him or going against him because of his alleged support for the Palestinian. That's a recent argument that came up, but that's not in here. But so the court says, look, the court says on the second issue, there's no requirement for the minister to delegate or functions under the Fugitive Offenders Act to any other person. Section 27 of the General Interpretation Clauses invoked in support of the argument is a provision of general application. It really isn't designed to compel delegation in individual circumstances. So the minister doesn't have to delegate our authority to anyone, and it does not operate to require the minister to stand aside whenever a political opponent is subject of executive action. And then she rejects the claim or the suggestion that the director of public prosecution could have served as a suitable delegate. She says, well, that office was not contemplated for by the Fugitive Offenders Act, and then she cites a Kenyan decision in support of that. And then she says, well, the same thing applies to the Attorney General delegating his advisory function. No submissions were made identifying to whom such delegation could have appropriately been made, and the court found no merit to the contention. And then she looks at the broader statutory framework within which the authority to proceed sits, and she says, well, the ATP does not convict anyone, it does not commit anyone to custody, it does not surrender anyone to a foreign jurisdiction. What follows the ATP is a full committal hearing before a magistrate, at which the appellants are legally represented and entitled to contest the request. Right? If committed, they may file a habeas corpus petition, they may appeal, they may seek independent judicial scrutiny, and the Minister of Home Affairs has no role to play, neither does the Attorney General. And then she says the court concludes that these structural safeguards are not incidental, and they dismiss the appeal. So they go now to the Caribbean Court of Justice, which I know y'all are interested in hearing. And they filed a notice of urgent motion, and they sought a stay of proceedings for the extradition of the appellants before the court of committal presided over by Magistrate Judy Latzman until the determination of the substantive appeal filed herein. And then they asked for the matter to be heard urgently. And then they asked for such orders as may be necessary. And so the Caribbean Court of Justice received that, and it scheduled a case management conference for yesterday. So the Caribbean Court of Justice moved very swiftly to address the situation at hand for the Mohammeds. And so following the case management conference, the Caribbean Court of Justice issued a decision setting timelines for the respondents to file their materials, because of course the appellants filed their materials. They filed a voluminous affidavit with about 58 exhibits attached to it, and so the Attorney General and the other respondents have to file their materials by the 2nd of April 2026, and then the parties have to file their written submissions not exceeding 20 pages in respect to the application for special leave on or before the 10th of April. And then the parties shall file written submissions in reply to each other by the 15th of April. And then the special leave is fixed to be heard by the 21st of April at 9 a.m. And then this is what this is interesting what the court said. The court said the hearing of the application for special leave shall be treated as the hearing of the substantive appeal. So if the hearing of the special leave is being treated as a substantive appeal, then every single argument that Azruddin Mohamed and Nazar Mohamed and their legal team has to make, they will have to make it right there and then if the special appeal is being treated as the special leave application is also wrapping up the substantive appeal in it. So what will happen then is the court will determine at the end of the day whether it will grant special leave to appeal. And if the answer is yes, then it considers the substantive merit of the arguments, including the bias arguments that the Mohammeds will make before it. Right? So that is how I read it, right? If the special leave is going to be treated as a substantive hearing. And then it certainly gives them time limits. But this is what is important. It said an interim stay of the proceedings for the extradition of the intended appellants before the court of committal presided over by Magistrate Judy Latzman is granted until the determination of the special leave application and or the substantive appeal and or until further orders of the court. So essentially, this essentially says what I was just explaining to you, that the court has wrapped up. So there's no sort of so the court is hearing everything at once. And if it's hearing everything at once, if it says, look, if it says we're granting special leave to appeal, then it goes on to consider the substantive merit arguments that Mohammed lawyers will be making. if it agrees with the magistrate court, the high court, and the three members of the Court of Appeal. So these are five jurists from Guyana that made decisions on the Azruddin Mohamed case so far. The magistrate, the Chief Justice, the Chancellor of the Judiciary, together with Justice Rishi Prasad and Justice Harnanan. So five of them made decisions. If the Caribbean Court of Justice agrees with the five jurists from Guyana that this case has no merit, it will simply say, well, your case has no merit. Right? So that's one prong of the test. The other prong of the test is the public interest, whether there's a public interest in the ventilation of this appeal. So the events that give rise to Azruddin Mohamed's extradition did not occur because Azruddin Mohamed ran for political office in Guyana, or at least that's the argument that that the respondents, the Guyana, will make, that Azruddin Mohammed's was are not as a result of him being involved in the political process in Guyana. Quite apart from it, they will argue that it arose from the Department of the Treasury of the United States of America and the other investigative bodies, right? That in June 11, 2024 sanctioned the Mohammeds, right? Because on June 11, 2024, the Treasury Department in the United States issued a release saying, today, the Department of the Treasury's Office of Financial Assets Control sanctioned members of one of Guyana's wealthiest families, Nazar Mohamed, and his son Azruddin Mohamed, their company Mohammed's Enterprise, and a Guyanese official for their roles in public corruption in Guyana. Additionally, OFAC designated two other entities, Hadith World and Team Mohammed's racing team, for being owned or controlled by Mohammed's Enterprise and Azruddin respectively. These individuals and entities are sanctioned pursuant to Executive Order 13818, which builds upon and implements the Global Magnitsky Human Rights Accountability Act and targets perpetrators of serious human rights abuse and corruption around the world. So Guyanese critic wrote, and he says, in relation to your opinion, sir, I beg to differ. The Mohammeds have win. Everybody is saying they win, and they think, say in their heads, why should I believe you? Well, I'm not speaking or issuing an opinion of my own. What I'm doing is going through the judgment of the magistrate, the judgment of the Chief Justice, the judgment of three jurists in Guyana, and what the Caribbean Court of Justice says at the moment that it will do, right? It says, look, we will determine whether or not special leave should be granted. And special leave is controlled by two factors. One of the factors is whether the case has merit. The case has to have some merit for the Caribbean Court of Justice to substantively delve into it. And there has to be a public interest in it. So, Yes. So Rovin asked whether April 21st the CCJ will have the final say. Yes, but it doesn't necessarily mean they'll render their judgment on April 21st. Maybe they may issue a bottom line decision. If they could reach a decision, they might issue a bottom line decision saying the appeal is granted with reasons to follow, or the appeal is dismissed, right? Or they could say, well, there's a lot of things for us to consider here, so we're going to reserve our decision, and you will be summoned to appear before us at another date in due course. So those are three different pathways that the court has. Andrew Cumberbatch says, well, for the time being, for some people who think it's permanent, well, it's not permanent. It's an interim interlocutory decision, which essentially tells the magistrate, look, hold your hands. Don't do anything at the moment until we hear this application for special leave or the substantive appeal itself and come to a determination. So in this case, there's no permanent stay. There's no permanent stay, and not only that, but unless something happens in the intervening period, so Wayne Narayan asked me an interesting question. Wayne says, well, what is a stay? A stay is, in other words, you put something on pause, you put it on ice. So it's like you're trying to make a decision. You're trying to make a decision to go to Guyana, and somebody says to you, well, like your financier, right? The person who is going to pay your airfare, pay for the hotel, arrange your transportation may say, look, man, when you can't travel to Guyana right now because I have to work out some issues. So just pause going to Guyana until I make a determination of certain issues. And after I make that determination, you will know whether you can go to Guyana or not. Or you want to send your kid to camp and you put it on pause. So essentially then, Jason asked, can the CCJ grant a permanent stay? Yes, the CCJ could grant a permanent stay, this, which is essentially quashing the authority to proceed. So if the CCJ grant if the CCJ says, well, we're quashing the authority to proceed, then that's in essence a permanent stay. Eric asks, well, how long do you think this entire case can last? Well, I mean, Eric, the proceedings, right? As you can see, the proceedings from the magistrate court to the High Court to the Court of Appeal to the CCJ was dealt with in an expeditious manner. The proceedings now at the lower court level on the merits before the magistrate is proceeding at a snail's pace, right? The proceedings started since January 6th of 2026, and now it's March, the end of March, and only one witness has been heard from, right? The Permanent Secretary in the Ministry of Foreign Affairs. They still have to hear from the Minister of Home Affairs. They still have to hear from the Minister of Foreign Affairs, and they still have to hear from the detective superintendent from the special branch, Prem Ryan, and a few other witnesses. So the hearing on the merits could go on for years. it could go on for years. I mean, we have the election case going on before the acting chief magistrate, and that case is in its sixth year now. It's in its sixth year now, and you never know. It might go until 2030 by the looks of things. So um, I can't predict when the case before the magistrate will end, because the case before the magistrate is on pause right now and it's going at a snail's pace. But the interesting thing about the case before the magistrate is when the CCJ makes a decision, there could be a do-over. So if the I don't know what arguments the Attorney General will make, but the Attorney General the Attorney General certainly can make arguments and say, look, this case can proceed as a viva voce hearing where you're hearing live witnesses, or it could have been a paper committal. Both options exist in Guyana for committal proceedings in criminal matters, and we say that the same applies to committal proceedings where extradition is involved. Assuming that the CCJ agrees, then when the matter is remitted back to the magistrate court, if it does, then the magistrate could simply say, well, having regard to the decision of the CCJ, we're going to do a paper committal. We're going to consider this matter on its merit by a paper committal proceeding, so no witnesses are required. Wayne says, well, what is the procedure of changing the magistrate? Is that possible? Yes, it is possible. In the election fraud case, the magistrate was changed because she was ill for a significant period of time. In this case, you never know what can happen, right? Assuming the magistrate goes on leave, and she goes on 6 months leave, right? Because I understand she applied for leave. I don't know how much leave she applied for, but assuming that she applied for long-term leave, if she goes on leave and the matter is remitted back, the matter has to continue, right? And the matter could always be assigned to another magistrate. Richard says, could a request be made to move the hearing from the magistrate court to a higher court? No, because it's a committal hearing, and if it's a committal hearing, then the magistrate does not, then the higher court does not have jurisdiction. So the magistrate would have jurisdiction, but the higher court would not have jurisdiction to take over the matter and deal with it in a substantive way. I just blocked somebody named Ali Saif because you can't come on my live and talking nonsense, because this is a live broadcast designed to sort of have a discussion with lay persons, answer questions, and engage in dialogue that is respectful and two-way. Yeah, so I've answered Wayne's situation. What is the procedure for changing the magistrate? Is that possible? Yeah. I mean, the chance of the judiciary could change the magistrate at any point, and for no reasons or for reasons, right? Just issue an order saying magistrate JA is removed from the case, and Magistrate CD is now the case is now reassigned to CD, and there doesn't have to be any reasons issued for that decision. That's all within the chance of the judiciary domain. Mabina says, well, can you do a comparison with the Jack Warner case and this one? I mean, yes. I mean, one of the biggest comparison that you could do between with the Jack Warner case and this one is both Jack Warner and Azruddin Mohamed are wealthy individuals. And so, Jack Warner case has been around for decades. And Jack Warner hasn't gone anywhere. But his children have paid the price for him. Like I said, Azruddin Mohamed case, it's gone to the CCJ already. It could go to the CCJ 4 or 5 times before the case is finally determined, because Azruddin Mohamed has the money to appeal each and every decision. And they have the money, and because they have the money, Jason asked me, any ruling by the CCJ is final? Yes. But Jason, remember that the CCJ case is on a narrow issue. It's on a narrow issue. It's on the issue of bias, whether or not the authority to proceed was tainted by bias on the part of the Minister of Home Affairs. That's all. There's no substantive merit on anything that the magistrate is doing. And I think the Court of Appeal and the Guyana High Court answered the question very well. They said, look, there has to be procedural fairness. There has to be natural justice. Jack Warner's children were taken into cut. If you Google it, you'll see that Jack's children were detained by the U.S. authorities. The only person that really hasn't paid the price in terms of a penalty or being in U.S. custody or accounted to the U.S. authorities is Jack Warner, but his children were. Vishal says, do you think the magistrate court is taking too long to give a judgment, not only in this case but other cases too? Well, it's not really the magistrate that could be blamed here. I mean, there's a process, and the magistrate has to sort of go along with some of what is going on. So, if Azruddin Mohamed says he has dengue fever, the magistrate did what she could do. She called the doctor to verify the authenticity of the medical note, and she asked the doctor certain questions as to when he thinks that Azruddin Mohamed will be in good health, and the doctor said 2 weeks. Well, I mean, the naysayers, I don't mean the naysayers in a bad way, but the naysayers would say that Azruddin Mohamed did that so that the CCJ hearing and this interim stay could be granted before the matter continued. So he just got this medical note so that the matter could be heard before the CCJ, before Justice Magistrate Latsman do anything else. That's what the naysayers would say. I don't know. I'm not a medical doctor. I have to go along with what the Justice of First Instance found. She found that it was legitimate, and she granted the adjournment. Well, now it is stayed until further notice, and we'll have to stay tuned to see. But yes, these matters are taking too long, but I mean, I don't think the magistrate could curtail the cross-examination if Azruddin and Nazar Mohamed lawyers want to spend 3 weeks or a month or 2 months cross-examining one witness. Sometimes lawyers do that to break the witness down because the witness gets worn out the more you cross-examine them, because obviously if you're cross-examining a witness for 2 months, even if the witness is the most truthful and the most credible witness, the witness is not going to remember everything he or she says under oath. So sometimes they do that to catch the witness in a credibility trap or inconsistency trap. So we don't know how long more this this Foreign Affairs Permanent Secretary is going to be detained. Kerry asked, well, I would like to know if the Mohammeds have any chance of winning the case at the CCJ. Well, it depends. I can't say, but it depends on how the CCJ views the minister's duty. It depends on what principles the Caribbean Court of Justice finds attractive, right? For an administrative decision in the context of this minister, right? So it's all contextual. It's all contextual to the statutory role and all that sort of stuff. So it's an interesting case, and it's going to be an interesting decision. Because somebody asked me to compare Jack Warner's case with Azruddin Mohamed's case. Well, one of the comparisons is that Jack Warner case went to the Privy Council. Azruddin Mohamed's case is going to the Caribbean Court of Justice. The Caribbean Court of Justice doesn't necessarily endorse decisions from the Privy Council, and likewise the Privy Council doesn't always accept decisions from the Caribbean Court of Justice, and you saw that in decisions such as the Chandler decision, the McKeown decision that I appeared on before the Caribbean Court of Justice, and Marcus Bishram case. So those cases are sort of examples of where the Caribbean Court of Justice and the Caribbean Court of Justice and Privy Council, they differed. They reached different conclusions. So it's not a foregone conclusion that it's not a foregone conclusion that they're going to reach the same decisions as Jack Warner's case. They may disagree with some of the rulings of the Privy Council. It's as lawyers, Kerry, we always tell clients, you have a 50-50 chance of winning. It all depends on the jurist. I mean, the thing about it though is if you look at the track record, right? If you look at the track record though of the Caribbean Court of Justice, is the Caribbean Court of Justice has overturned most of the decisions that came out from the Guyana Court of Appeal. So most of the big decisions that came out of the Guyana Court of Appeal were overturned by the Caribbean Court of Justice. They didn't agree. Even in one of the cases that I appeared before recently, they overturned that decision, and all three of the Court of Appeal judges had agreed. That was the parliamentary secretary's case. Bim asked, can they be remanded to prison? They could, but at this point, the only way they would be remanded to prison is if they breach their release conditions, because they're released on bail right now, and they have to breach those conditions in a way where the magistrate finds to be objectionable or egregious. But a minor breach, that's why she expanded the time they should report. A minor breach like reporting 12 o'clock when you should report at 1 o'clock is not going to be a good reason for the magistrate to say, well, I'm going to extreat your bail and remand you into custody. That doesn't happen like that. Mobina says that's why the Mohammeds should go to Miami and figure it out. Well, the Mohammeds, the Mohammeds have the money, right? Sometimes these laws don't get tested enough because people don't have the money or the fight to fight. The Mohammeds have the money and they have the fight to fight. So, it's going to create very good jurisprudence for the Commonwealth Caribbean. They may well end up going to Miami, but they're they're going through the judicial process, and so we have to let the judicial process run its course. Jamal says, can we have a second doctor's opinion? Well, the prosecution had asked for a second doctor's opinion. They had asked for a second blood test to be done, and the magistrate rejected that. So no. Jessica asked the same question. Why wasn't the state lawyers asked if they could have done an independent testing? Yes, the state lawyers asked for that, and it was rejected by the magistrate. Judgment is based upon when substantial evidence is proven beyond a reasonable burden of proof. Judgment is based upon when substantial evidence is proven beyond a reasonable doubt. I think she meant to say, no, that's not what committal proceedings are. Committal proceedings are just like preliminary inquiry proceedings. It's based on a balance of probabilities, really. Whether there's enough evidence that a jury properly informed can find the person guilty. And Kamini says, so this case will set a new precedence in the Caribbean? Yes, because the issues that the Mohammeds are bringing to the CCJ are issues that it hasn't determined yet. The CCJ has only heard one extradition proceedings. Recently, it had a 7-member bench. And heard a case from Belize. It hasn't rendered a decision yet, so what's going to happen is the court might hear this case, and if it has similarities with the case that it heard from Belize, it may well render those decisions together or one after the other. Critics says another round of dengue fever loading. Well, dengue fever is bad. One of my nephews in Guyana had dengue fever, and he was in hospital on IV and all kind of stuff. So it's not, if it's true that he had dengue fever, then that's bad. But if we see him walking around, tomorrow or next week, when he's supposed to be on bed rest for 15 days, then it's going to be a problem. It's going to be a problem because, people are going to say, well, he said that he had to be on bed rest for 2 weeks. What is he doing walking around? Hey, squaddy, what's going on? One of my squaddies in New York is on the live. Let's see what other questions. Vishal asked whether I think that the Mohammeds are fighting a winning case overall. Well, I don't want to comment on that, right? I don't want to comment on that. All I will say is what the courts in Guyana said, right? The magistrate court, the high court, and the Court of Appeal said that the Mohammed's application on the basis of bias to quash the authority to proceed has no merit, right? That's all. That's what I will say. Those are the decisions of the courts that their case has no merit. We will see what the Caribbean Court of Justice say, whether they come to the same conclusion. Now, if the Caribbean Court of Justice comes to the same conclusion that the case has no merit, that the minister exercised her discretion in the manner in which the statutory authority or the statutory powers that she has under the Fugitive Offenders Act, if she says that, if the court finds that she did, then they may say, well, we don't even have to consider this appeal on its merit. This appeal, the special leave is dismissed, right? The court can do that. So I don't know if they have a winning case. I'm not going to predict whether they have a winning case or not. Rajendra has an opinion on how the permanent secretary for the Ministry of Foreign Affairs has been treated. I can't read that comment. Niran, he says one of the flaw or inconsistency in the cross-examination could cause the entire case or cause it to be completely dismissed. No, but it could, inconsistencies, right? Credibility concerns can have, if the witness isn't reliable, because you could be credible but not reliable. So if the witness isn't reliable, then a jurist doesn't have to a jurist could disregard the witness evidence as a whole, or could disregard part of the evidence, which is the evidence that the jurist find not to be reliable, and base his or her decisions on the reliable part. Jason said, can they go to the Privy Council? No. The Caribbean Court of Justice is our highest court. They can't. Jamal, the issue of whether the magistrate is biased or not is not before the CCJ. It's whether or not the minister who issued the authority to proceed is biased. Right. So yeah. So all that's happening in Guyana is the magistrate is determining whether or not there's evidence to extradite the Mohammeds on the basis of the indictment. On the basis of the indictment that is before the court in Florida. Yes, Amanda Payne, they do have the right to a fair trial, and fairness. Well, they have the right to a fair trial, but as the court in Guyana said, fairness applies across the board. Fairness applies as well to the authority to proceed. That is established. So Guyana is dotting all the I's and crossing the T's in this case. John Prasad asked me a question. We can't predict how long these cases take. That's the simple answer. A case that you predict could be 4 to 5 years could go for 5 years. Sometimes these cases could snowball out of control. Sean Peters made a comment that I'm going to delete because it's completely inappropriate. It's completely inappropriate to make a comment like that concerning the jurors. And so I blocked Sean Peters because he's not even on my friends list and he's making comments that are quite inflammatory to the reputation of the jurors. I'm not even going to repeat what he said, but I deleted him and blocked him. Not on my page. So that comment was deleted. What does the law, sir, what law does bias trample on? Well, bias doesn't really trample on laws. Bias tramples on people's state of mind. Bias is a state of mind. Whether or not you could judge a case fairly. Essentially, some bias are perceived bias and some bias are actual bias. Some bias doesn't even have to be apparent on its face. Can the government confiscate their property for unpaid taxes? They owe the government $191 billion. The problem, Jamal, is that there's going to have to be a process. There's going to have to be a process in order to forfeit anybody's property. And then there has to be judicial findings, none of which have been made as yet because there's no case against the Mohammeds for taxes that they owe. Can the U.S. do a Maduro-style kidnapping and take the Mohammeds away? Well, let's hope that they don't do that, Anand. Let's hope that they don't do that. I mean, I don't want to say much, but I mean, what happened to Maduro and his wife, irrespective of how bad or good they are, or indifferent, should not occur in any country. The U.S. has no business going into countries and sort of plucking out their leaders and killing all their security forces. They killed the entire security team that was guarding the president of Venezuela and his wife. Right? Most of them were Cubans. They killed them all. And then, of course, they went into Iran recently and killed out the entire upper layer of the polity. Right? They killed out all those leaders. So it's the second tier now has risen to the top because all of the top leaders, whether they were military or government or judiciary, they're all killed out. So Donald Trump is on really skating on thin ice right now with all this sort of stuff that he's doing around the world. It's not acceptable. Like these are fundamental. Like in Lebanon right now, there are over 1 million persons that are displaced, internally displaced. They have no place to go. They're living in tents. They don't even know where their next dinner is going to come from. The population of internally displaced people in Lebanon is larger than the population of Guyana. I don't even know what the population of internally displaced people in Iran is right now. But the entire Middle East is in turmoil because of the actions of Trump. So you asked the question about whether the U.S. can do a Maduro-style kidnapping. I don't think anyone, irrespective of their political allegiance in Guyana, wants the U.S. to come into their country kidnapping people. It sets a bad precedence. Right? So I wouldn't support that. And I'm not friends with the Mohammeds. What is your take on the derogatory comments and slander against Magistrate Judy Latzman? Ollie David asked. I think the Guyana Association of Women Judges, the Guyana Bar Association, And the other association, the other law associations in Guyana um, should deliberate on this issue and should issue statements, because we've had that, we have that in Canada, where comments are made about judges, and the various bar associations issue statements supporting the judges. You know, so if there are statements that are made against Judy Lasman that are defamatory and slanderous, um, she should be defended by the bar associations. Parmanan says, what happens if Judy rules in favor? She means, no, Parmanan is he. Parmanan says, what happens if Magistrate Judy Lasman rules in favor of the Mohammeds? Well, if she rules in favor of the Mohammeds, the government has the right to appeal, right? The government has the right to appeal. And if she rules against the Mohammeds have the right to appeal. So it's a whole merry-go-round to the Caribbean Court of Justice. So they'll have rungs to the Caribbean Court of Justice. Hamer made a comment, and I'm not going to read the comment. PRI says, well, is this a trial or a committal process? It's a committal process, just like a preliminary inquiry. So no, it's not a trial. It has the trappings of a trial, but it's not a trial. It's simply a committal process to determine the sufficiency of the evidence. It's beyond fairness and masquerade at this point, based on what is being played out in the magistrate court. Well, I mean, the Mohammeds have the right to challenge the evidence and to challenge the process along the way. So I understand the frustration, but they have resort to natural justice and procedural fairness. That's all I will say. It is a committal process. It's not a trial. Well, the magistrate, Leighton asked, how could the magistrate in Guyana make determinations as to whether the 11 indictments in Florida are justified? No, she doesn't make those determinations. She simply looks at the evidence to see whether the evidence is sufficient. She doesn't make no determinations as to what you're saying that she's making the determination, and that's not what she does. Her role is pretty simple and circumscribed. Her role is simply to determine the sufficiency of the evidence. That's why they're questioning the permanent secretary at length right now. No, the past entanglements aren't really making the the extradition proceedings more difficult. I mean, the Mohammeds and the government were like they were very close. They were very close. And there has been a falling out, and with some people the falling out is bitter, but the Mohammeds are very powerful people in Guyana. They still are powerful people. They still have a lot of people in Guyana who respects them. They had over 100,000 votes, right? I mean, Mohammed came out of nowhere and became the leader of the Republic's opposition. He's a very powerful man in the political hierarchy now. I mean, the president has to sit down with him to figure out who the next um, chairman of the election commission will be. They have to discuss the commission of police. They have to discuss certain service commissions. So, you know, a lot of things they have to discuss. So, um, Mr. Mohammed has a lot of power and influence. Lily says it's an extreme sad situation in the Middle East. I agree. It's horrible. Could the government move to the High Court if the magistrate rules in favor of the Mohammeds? Yes. Can a lawyer can't a lawyer and judge or magistrate visa get revoked? Yes. Yes, the US does that. The US does that a lot. The US for example, the US revoked all the judges at the International Court of Justice, the ICJ, when they tried to pers- prosecute the Americans for alleged war crimes in Afghanistan. Donald Trump revoked all their visas. John Prasad asked a question. I can't answer that question. Can the Mohammeds cut a deal? John Prasad asked, can the Mohammeds cut a deal with the US? Or is it too late for that? No, it's not too late. In practice in these matters, um, lawyers are always talking and trying to see how matters could be resolved. So yeah, the Mohammeds can instruct their lawyers, the American lawyers, of course, because the lawyers in Guyana have no standing to practice in Florida, but they can instruct their American attorneys to negotiate with the prosecutors in Florida. Anna, no, that would never happen. No, there's not. So right. So if the magistrate, yeah. So if the magistrate rules against the Mohammeds, Harry. So if the magistrate rules against the Mohammeds, they'll be taken into custody. But I expect that the Mohammeds would have a notice of appeal ready, and they would file for bail. They would file the appeal and ask for bail pending appeal. So that's the process. You ask for bail pending appeal, and the court assessed the case, and more likely than not, it will grant bail pending the appeal. But I'm just saying that it may the court could also say no, we're not going to grant you bail pending appeal. But I think in the Mohammed's case they would get bail pending appeal. Well, Leighton asked a question. He says, how does the responses of the PS Sharon Rupchan affects the outcome of the case when all she did was collect the package and presented it as a relative authority? Well, we don't know what happened there, right? The magistrate has to make a determination on that, so I'm not going to comment on that. Can the CCJ remove the sanctions and indictments? No. But the CCJ, if the CCJ quashed the authority to proceed, in effect it's doing that. But it can't quash that. But it could quash. It has jurisdiction on the Guyana law to quash the authority to proceed. All right, so I think I've answered all of the questions that were asked, and I thank all of you for being on the live and for engaging with me. I meant to do a live of this kind for a long time, and I never had the chance to. But today I decide I'm gonna do this live, and then you know head out. So I'm in the office, one of my offices. So I'm gonna head out now. Thank you very much for tuning in. I tried not to express my own personal opinion. I tried to stick to what the decisions of the courts were, and I tried not to express an opinion. I simply answered some of the questions based on my experience as a lawyer, and I wanted to do that because I have to be very careful how I deal with these sort of things. Just give me a second before I sign off.